Yes, by order. It has come by order. Why? This is not going to happen. You have to pay cost. We do not know. Sri R.I. Bhuya, learned counsel for the petitioner, has sought adjournment of this case, full stop. It, however, appears that the case has been listed on the strength of a mentioned memo, which was filed yesterday. Para? Then where is 11? Who is for 11? Are you appearing for 11? Then what is your name? Are you there in this matter or not? Then why are you mentioning? So this is not your case. Why are you mentioning? So why are you mentioning? This is somebody else's case. Who instructed you? We have to see the file, not like this. Not like this. Yes. Let the matter reach. Yes, Mr. Let us issue notice. Let the matter reach. If they want to file, we'll issue notice, formal notice. Okay. Yes. When? Today not possible. We told you yesterday. Today is not possible. Not possible. Yesterday you should have mentioned. Yesterday we told you, do it yesterday. Mention it yesterday for today, no problem. Today will not be possible. You can have it in the reopening. Or if you want, you can have it in the, there is another bench 5. You can try it there. Okay. Try that. What is the matter? Motion matter. Motion. Admission, why in the vacation bench? Vacation bench are only for urgent motions, not for items like this. Sorry. Have it after the reopening. Yes. এটা মই কেনেকৈ কৰিম মইতো বহিব জানো কিবাৰটোত কেনেকৈ যাব এতিয়া এইটো এটা কৰিব দিয়া যোনটো আহিছে এটাতো আহিছে এটাও অহা নাই মইতো বহিবলৈতো কৰিব নোৱাৰিম Yes. Sri A. Sharma, learned counsel for the petitioner, has submitted that the order dated 6 to so and so passed in so and so has been complied in the meantime. Para. In view of the aforesaid and therefore and therefore he does not want to press this application. Para. In view of the aforesaid development and the submissions made, the contempt petition is closed. Item 2. H. Barwa. P. Bora. H. Barwa was here. Who H. Barwa? Yes, where is the counsel? None appears for the petitioner on call list after the vacation. I didn't read. How much is the amount? $31 lakhs. Why have you paid 31 lakhs? If the loan was for 2 lakhs, how much is the interest? What do you mean by a cost title? What is a cost title? Come to page 2. Is this a kind of a cost title? No. Come to page 2. You should know the difference between cost title and pleadings. A cost title goes for one cost title goes for more than 1 page. Sentences after sentence in the cost title. This is how you present a petition. Kindly come to page 2 of your petition. What is this? What do you have to state in a cost title? If you know it is the projection of brief in 2-3 lines, what if you made 2 pages? No, you should take care of this. This is not how you draft or present a petition. There are full stops, there are at least 4-5 sentences in one cost title. These are pleadings. Don't convert pleadings into cost title and cost title into pleadings. And you are not a new counsel, you are such a seasoned counsel. Coming from you, it's really surprising. What is the cause of action? Yes. You are the borrower. Younger brother was the borrower. He passed away. Thereafter, 1993. Yes. 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 Thereafter. Who are the respondents? AFC has a standing counsel. AFC, Assam Finance Corporation. Yes. Madam T. Goswami. Why don't you serve her? Served whom? You have served the finance department? No. T. Goswami. You serve a copy on T. Goswami. This can be disposed of early. We'll have it immediately on the vacation. Okay? Third, 3 F.K.R. Ahmed, learned counsel for the petitioner, who is aggrieved by non-return of the mortgage documents even after payment of the even after repayment not only of the amount borrowed but of a much higher amount. Full stop. It is also the case of the petitioner that the borrower was his younger brother who has expired, and since the present petitioner is a co-patadar, comma, he had made the repayment. Para. It, however, appears that the Assam Finance Corporation has a standing counsel who has not been served. Full stop. Let served a copy of this petition. Para. Let a copy of the petition be served upon the learned standing council, and the matter be listed for motion on 15th of October. Where is the FCR party? Huh? 5. In the eminence court title. Okay. T. Goswami, Madam T. Goswami is there. Serve her. Yes, next. Item 4. Mr. Mishra. Yes, state tax, finance. Mr. Gogoi or Mr. Chalia? Okay, wait for a while. Item 5. In fact, we have heard this matter at some length. He had raised the other issue. Okay, we'll try to have him on board. He wants to appear online after a while. After a while. Item 6. Just a minute, please. Just a minute. Just a minute. Yes. Item number 6. Yes. Who is respondent number 2? Okay. Yes. Okay. What is your name, madam? Your name? P. Ahmed. You are not on record. And appearing on behalf of whom? Heard Ms. P. Ahmed, learned counsel, appearing on instruction of Sri M. I. Hussain, counsel for the petitioner. Full stop. The grievance of the petitioner is against the inaction of the District Commissioner Dhubri in taking huh? Darang. Page. District Commissioner Thubri, in taking onward action on the application submitted by the petitioner seeking enhancement of the compensation amount with regard to acquisition of land. Full stop. It is submitted that on 2/8/2025, such an application has been filed for making a reference to the appropriate authority. Full stop. Para. Let notice be issued returnable on 29th of October 2025. Revenue Department, Madam Mohanto, PR Mohanto 1. Yes, Mr. Hendrik for 2, 3, and 4 extra copies. Okay. कहीं से नहीं 2 is not your matter, Mr. Barua. 2. H. Barua. 2. Who's 2? Okay. Yes, Mr. Mishra. We've got the instructions, Mr. Barua. What is your instruction? You have made a demand. The grounds of challenge is that the show cause notice is vague, number 1. Number 2, there is no particulars of the mismatch. Those are your grounds. No digital signature also. Yes, what do you say? Then we have to issue notice then in this case. Heard 3 R. S. Misra, learned counsel for the petitioner, who is aggrieved by an order dated 5/3/2024 issued by Response number 3, whereby a demand of rupees 65,52,344 bracket so and so has been made by invoking section 74 of the CGST/AGST Act 2017. Full stop. The said demand was initiated via the show cause notice dated 22/6/2022. Full stop. Para. Amongst other grounds, it has been urged that the show cause notice is vague and there are no particulars of any mismatch between the TDS and the return. Full stop. It is also urged that the same does not contain any signature of the issuing authority. Did you submit your show cause? As a result of which the petitioner was deprived of an effective opportunity to defend himself or itself, Para. When this matter was taken up on earlier occasion, directions were given to the Learned Standing Council to obtain instructions. Full stop. 3. H. Barua, Learned Standing Council. Learned Council appearing on instruction of 3. B. Gogoi, Standing Council, Finance Taxation Department has submitted that instructions have been received and he would file the affidavit. Para. Let notice be issued, returnable by 6 weeks. Just a minute. Sri Barua, the Learned Council, accepts notice on behalf of all the respondents, not all the respondents, respondents 1, 2, and 3. Extra copies, 4 registered post with AD. Okay. What is the stage now, Mr. Mishra? That we cannot do. The defreeze we cannot. List along with WPC. 4999 of 2025. তার আগত লিখিবা হলো 3 Mishra prays for an interim order and has submitted that the bank accounts of the petitioner has also been freezed, full stop para. After considering the interim prayer, it is directed that no further coercive measures be taken against the petitioner till the returnable date. That's what tag along with, huh? Yes, next. Article 7. Yes. Okay. You have written to the deputy commissioner. Which district? Dhubri? Same case. Okay, মাত্র মারিছে এটা। সেই মাত্র মারিছে। Item number. The earlier was what? Item numbers? Okay, 6 একে মারিছে। P. Ahmed on behalf of M.I. Hussain. Same. Yes. Land has been acquired.
Now, while the authority have paid the compensation, they have released only 50% to the private respondent. 50% has been directed to be deposited before the learned session. That's the order is under challenge. Notice.
Why are you challenging?
We are challenging it because nothing has been said. So we have the complaining before the learned authority. The speaking order, my lord, these 2 points is it.
Part 3A are Bhuya learned counsel for the petitioner who is aggrieved by an order dated 7/1/2025 passed by the respondent number 5. Full stop. It is the case of the petitioner that in respect of compensation for the Jirat pertaining to the Bharatmala project, the impugned order has been passed whereby one part of the compensation has been released to the private respondent and the other part has been directed to be kept intact. Para, let notice be issued. Who are you?
Our attorney of the land, and the rest is
The petitioners claim to have right, title, and interest over the land in question. Para, let notice be issued, returnable by 6 weeks. Revenue Department, Madam P.R. Mohanto. 1, then Union of India, Ministry of Roads. Is it there in the court? B. Chakraborty. 2, CGC. Then NHIDCL, Madam R. Bora. 3. Then DC, ADC, 4 and 5, BJ Talukdar. 6 and extra copies. 6 and 7 registered post with AD. Steps within when? Within 2 working days, huh? Sri Bhuya, learned counsel prays for an interim order. Para, after considering the same, it is directed that the amount which has been kept intact is not to be released without taking leave of the court. Item 9. He said, BA, he said. Yes.
Thereafter, he filed an application with the district commission for the time. That has been not considered. Therefore, he appealed the petition of the filing it. Yes, this petition will be on for 2020. that have been considered that in this order is worship, it was directed that the process has been completed of this that has been not considered. Therefore, filed as contempt as well. That has been closed by this honorable court as per the instruction placed by the council of the psychology. If your worship will find evidence 23 of the their worship and the sanction order has been placed before this court. That is in here 3/2024 as per the instruction, the sanction has been accorded is as the prosecution and account number also been given in the
Where did the accident take place? What is the place you have stated? Two? You have, what have you written? What is Bhavanipura? Is it Bhavanipura? You don't even know the name of the place. The court is from Bhavanipur. You should know what is Bhavanipur and there is no Bhavanipura. Yes, yes. Some sanction has been made, but it has not been disbursed. Okay. Third. 3. S.I. Akand, learned counsel for the petitioner, who is aggrieved by non-disbursement of the ex-gratia amount, which has been stated to be sanctioned on 26/11/2024. Full stop. Such ex-gratia has been claimed for the death of the son of the petitioner in a road traffic accident on 26/2/2019. Full stop. Let notice be issued. Is it still available? Hmm? Sri N. Goswami, Learned State Council has, however, submitted that at present there is no such scheme for payment of ex gratia due to motor accident. Be that as it may, let notice be issued, returnable by 6 weeks. Yes, Revenue Department, PR Mohanto 1, Chaliha, A. Chaliha 2, District Commissioner 3, N. Goswami 3. Extra copies. This. Item 10. Hmm. Hmm. No, if the matter is pending consideration in the second appeal, where have we said? Under what circumstance? What was the circumstance? If a dispute is pending consideration in this court, and this is a different plot or what? Yes. No, after if you relinquish, if it's not relinquishing, it is giving for acquisition. Now the compensation part, how do you apportion the compensation? No, your dispute is against whom? No, regarding the apportionment. Is there a dispute? Then the title suits are for what purpose? When private respondents are there, they might make up claim. If they are tenants, they would be entitled to a particular portion. Okay, we heard Miss R. Chaudhary, learned counsel for the petitioner who is aggrieved by non-disbursement of the compensation amount for acquisition of land under the National Highways Act 1956. It has, however, been informed that for the land in question, there is a civil suit which is presently at the stage of second appeal in this court. Para. Let notice be issued, returnable by. No, sir, the learned counsel has contended that despite such pendency, the amount can be disbursed in accordance with law. Para. Let notice be issued, returnable by 6 weeks. Ministry Road Transport, Ministry, you'll take. Okay. C. Burwa for 1, 2.
And earlier petition also, earlier petition also, Lordship was style and dispose of that word is Assam. Other petition of style before you know, Lordship and order.
Okay, we will look into it. Okay.
Very bad.
Okay, you 1 and 2. You are for 1 and 2. 1. 1, okay. She wants to appear.
This I don't.
Now, regarding Union of India, Ministry of Surface Road Transport, you can appear. Okay. Then, okay. C. Burwa for 1 and 2. Then 3, 4, and 5. And Goswami. Extra copies. 6 and 7 registered post to ready. Steps within 2 working days. Steps within 2 working days.
This case is probably discussed now. Already the function of 24. And so far, by the other thing, concern on the same day, the final case was in the name of inaction, and same serial number was given to him also by the handling section. And accordingly, he mentioned. But this is not, there are some that is because same name is there. The same day.
Okay.
So,
Yes.
online also, my name.
Sri H. Talukdar, learned counsel for the petitioner, has submitted that this case has been wrongly listed as a mention was made for listing of a case wherein the name of the petitioner is same. Para, in view of the above, matter is, no orders are required to be passed and the matter be listed in terms of the order passed on 24/9/2025.
Item 12.
Yes.
But the forest officers will not in the contact will indicate survey and verbally will not, we have stated, in paragraph 4, page 27 of my petition, now they are saying that as these lands area is come within a forest, reserve forest, so therefore you have to vacate. Now, the once the notice.
Yes, notice, Mr. Goswami.
The land in question is in Jumuna, no longer reserve forest.
Mm.
And these two villages, there is no such village, these are imaginary names. Only they say, these routine survey on human habitation areas on so these are normal routine survey.
Yes. Mm.
And the instruction also say
That
Yes.
the frontline staff of Jamuna Valley Ranch, Dopoka district were conducted regular patrolling in city as well as routine survey on the habitation area of so and so that these are days.
Yes.
For assessment of the enforcement and households inside the reserve forest area. No fresh eviction drive will be carried out until order from the government. Order in this regard, the granting of gas pipeline connection, electricity connection, various panchayat level benefit that have been given.
Okay, yes, there is no apprehension,
Yes.
Mr. Bhuya.
So, also says, man, if any eviction drive is taken in future in the RF, it will be made sure that it maintains all the procedures given in the Assam Forest Regulation. And my lord, the judgment of the law.
We'll record this, close this. Okay. We'll close this. We'll record your statement. Yes. We have noted. We have noted you. Noted this. Yes. We have heard Sri A.R. Bhuya, learned counsel for the petitioners. Also heard Sri P.N. Goswami, learned AAG, Assam. Full stop, para. Considering the subject matter involved, comma, the instructions received by the learned AAG and as agreed to by the learned counsel for the parties, comma, this writ petition is taken up for disposal at the motion stage. Tara, please have your seat. The petitioners claim to be residents of Pub Jamuna Gaon and Paschim Moudanga under the Naumati Moza Doboka Revenue Circle in the district of Hojai and are landless and erosion affected people. Full stop. They have claimed to be residing over the area for a long span of time and are exercising voting rights and are having electricity connections. Full stop. However, on 7/9/2025, 8/9/2025, and 10/9/2025, surveys have been conducted by the personnel of Forest Department, giving rise to a reasonable apprehension of their eviction from the land in question, and therefore the present writ petition has been filed. Full stop. It is the categorical case of the petitioners. No, don't write it. Sri Bhuya, the learned counsel, has submitted that no notice of any nature has been issued till date, and the surveys made on the aforesaid dates have given reasonable apprehension of their eviction. Para. Sri Goswami, the learned AAG, has, however, submitted that as per written instructions received, comma, all the grounds urged in the petition are imaginary and not based on any materials on record. He has submitted that on the aforesaid dates, that is 7/9/2025, 8/9/2025, and 10/9/2025, though surveys were made, comma, those were routine surveys. Full stop. He has also submitted that there is no such village in the area in question which is a part of the Jamuna Moudanga Reserve Forest, which was notified in the year 1918, 1918. And as per law, there cannot be any, nobody can reside in such reserve forest. Full stop. He has also submitted that there is no move to carry out any eviction from the area in question at this stage, and if at all such a move is taken, the same will be done by following the due process of law. Para. Considering the aforesaid submissions, which are based on the written instructions, comma, this court is of the opinion that there may not be any existing cause of action to be espoused at the present. Full stop. Accordingly, the writ petition is closed. Full stop. It is, however, clarified that if and when any cause of action arises, the petitioner would have liberty to approach the court. You are for whom? Union is there. Or R.K. Chaudhary likhiye, upar R.K. Chaudhary and Deputy SGI is present. And you are also there. Oh, we have recorded his name. Doesn't matter.
Right.
Disposed of, huh?
Item 13.
1-3. Mr. Ahmed?
Yeah. Yesterday, that item number 22, 3.775. Only ward number is different, QP order is same.
Okay. Yesterday, item number? Give the, okay, give it to us. Same notice of motion. Notice was issued. What number? What is the ward number this time? Ward number 5. And the Gaon Panchayat is the same. Okay. Okay. Yes. And the respondents are also the same. Okay. A private respondent will issue notice. Okay. Okay. List along with her.
14.
Yes, what is this, Mr. Bhuya?
Yes, it is a law. So, it's some different. I'm not talking about the state of Assam, Milord, is restored more than 2,000 bigas, Milord, in Bilasipara, Milord, for the purpose of establishment of a thermal power plant, Milord. And as a result, Milord, the scheduled lands which we have mentioned, Milord, has already been acquired.
Yes.
In those lands, Milord, in some of the land which we were given the allotment, being the landless persons, Milord, that has already been acquired. The infrastructure which was there, Milord, has already been demolished also, Milord, the
Yes.
homestead land and the other properties also. Now, Milord, and the lastly, we have a portion of land near a national highway, Milord, and that land has also been sought to be acquired. Now, Milord, as per our instruction, Milord, though the land has been said to be acquired for the purpose of the same thermal power plant, but in fact that area is not, Milord, covered under the project, Milord. Now, for what reason, Milord, they are now going to acquire the last,
Yes, Mr. Wilson.
last folk,
But
Milord.
my specific instruction from the deputy commissioner is that, my lord, we have initiated this process for the thermal power project, my lord. There is no other
Project. No
other project.
Okay.
Secondly, my lord, these are patta holders, my lord. So the question of eviction does not arise once it will be settled. Now it is at the stage of fixation of compensation, and we are doing it. Though process was initiated under 1964 Act, compensation will be fixed under 2013 Act. My lord. That is the process which is going on now. So there is no imminent threat for the
No, what
for
we have understood from Mr. Bhuya
Man.
is that he is not questioning the acquisition as such. He'll get compensated, but the question which he's trying to raise is that this land is not a part of the project.
No,
So
it's a
it may
part
not
of
be required for, it may not come under the acquisition process.
It is part of the project. Well, and acquisition process is already.
My friend can file an affidavit.
Okay,
Milord,
okay,
that we
okay.
present.
Third, Shri A.R. Bhuya, learned counsel for the petitioners who are aggrieved by an acquisition process which has been initiated
1, 2, 3,
under
4,
Land acquisition.
the Assam Land within bracket Acquisition and Compensation bracket close Act 1964. Full stop. It is the contention of the petitioners that they were allotted lands which have been acquired for the thermal project, power project, full stop. The cause of action is, however, pertaining to a part of the land which, according to the petitioner, is not a part of the project for which the acquisition process has been initiated. Let notice be issued, returnable by 6/6, Sri P.N. Goswami, London, AAG.
2, 3, 4, my lord.
Revenue is.
Revenue, they
okay.
have their signing. also.
Okay, PR Mahanta, Miss PR 1, 2, 3, 4, P.N. Goswami. We'll do one thing. You have for 2 and 3, 4 we'll have for APDCL,
Yes,
we'll have for
yes.
KP Patrika. 4 KP Patrika, extra copies. Yes. But we cannot, Sri A.R. Bhuyan, learned council prays for an interim order. Para? The law relating to acquisition of land is well settled, and unless there is a case made out wherein there are violations of the statute, comma, such acquisition process cannot be challenged, and the only aspect would be on the question of adequate compensation. Full stop. In view of the above, comma, at this stage, this court is not inclined to pass an interim order. Full stop. It is, however, an inclined order. Yes. That it is needless to state that the petitioners, that all these petitioners and all the stakeholders would be entitled to a fair and adequate compensation under the statute holding the field. 15. Yes. What is this?
One of the CRPC. Allotment 93rd, page 211 of this petition, Annexure 35.
Why are you shying away from appearing and giving the documents?
I have already cooperated. Submitted the documents now, Lord, as per the provision of the law, under section 91, my lordship knows, that the same cannot be issued to an accused person. So that's why, we are challenging the maintainability of this.
Let us see 91 again.
Now, this 91 has been changed to 90, although it has been issued on 91. Under the DNS.
No, but it has been the same.
Content same.
Yes, yes.
When any court or any officer in charge of a police station consider that the production of any document, electronic communication, including communication devices which is likely to contain digital evidence or other thing is necessary or desirable for the purpose of any investigation, inquiry, trial or other proceedings under this Sankita or before such court or officer, such court may issue a summons or such officer may, by a written order, either in physical form or in electronic form, require the person in whose possession or power such document or thing is believed to be to attempt to produce it or to produce it at the time of place stated in the summons or order. Any person required under this section merely to produce a document or other thing shall be deemed to have complied with the requirement.
Yes, what is your submission?
I accuse, do not come within the definition of this person, which has been clarified in the many of the documents, as well as it will violate Article 20, sub-article 2 of the Constitution, Just for a moment, if I may.
Now 22 we are aware. Now let us see the judgment.
Just order similar. My
Page.
page number 16. One of the relevant part is that page 207 and 218 below.
Yes. Yes, yes.
Petitioner's right to remain silent during investigation, which is a guaranteed constitutional and legal right. The petitioner cannot be compelled to be a witness in his own case.
Yes, Mr. Tarudar. Which heard 3 A.R. Bhuyan learned counsel for the petitioner who has put to challenge a notice dated What is the notice? Page, notice dated 29/8, 2025, issued by the whom? CID. Deputy Superintendent CID Ulubari, within bracket response number 3. Please see. Response number 8. 8. By the said notice has been issued under section 99 of the CRPC, 91 of the CRPC, which has required the petitioner's presence with documents oblique information. Full stop. It is contended that the petitioner is an accused in the connected criminal case, and such notice would be violative of Article 20 within bracket 2 of the Constitution of India. What is 3? That's how it is Constitution of India. What is 2 then? Three. 23 is there. 22 is double jeopardy. 23, 3 of the Constitution of India. He has also relied upon certain judgments of the Honorable Supreme Court as well as this court to buttress his contention. Sarah, let notice be issued, returnable by 6 weeks. Let steps Sri B.J. Talukdar, learned additional edition senior advocate for all the respondents. Extra copies, okay? 3. Bhuya, the learned counsel, prays for an interim order and has submitted that prima facie the notice is bad in law, as it is explained in the judgment that the expression person appearing in section 91 of the CRPC within bracket 93 of the BNSS, 94 of the BNSS cannot mean an accused, inverted comma. Considering the above, comma, till the returnable date, the impugned notice dated 29/8/2025 is suspended. Again for time being. 5. Facing? Okay, we'll still consider yesterday. I think yesterday we have heard. Yes. Where is Mr. Roy Chaudhary? But we cannot wait. He is having some urgency. Let's see. That is why I fixed it today. Just a minute. Let us find out the notes. Just a minute. Primary grievance of it is against a notice fences and yes. He said that it is vested with the registrar as well as returning officer under 3B and 3D. Whereas this has been given by the president and the secretary. Notice has been.
The date of nomination, the withdrawal, the value, this is completely passed, and it is got to be passed. Because all these is by
11/9. 11/9. When was this writ petition instituted? 17/9.
because my lord, it went to the taking by the issue was different. Is it by the inclusion my lord of the private prescription? Saying that my lord, the requirement of the 1 year my lord membership is not fulfilled so far as they are concerned.
Okay, we'll issue notice. We'll examine the issue. Oh. What is your name, madam? Yes. Heard Miss A. Sharma, learned counsel, appearing on instruction of Sri P. Hendik, for the petitioner. Also heard 3 S.K. Talukdar, learned standing counsel, Cooperation Department, whereas Mr. P.K. Roy Chaudhary, learned counsel, is present for the respondent numbers 6, 5, para. This matter was considered on 24/9/2025 when an issue was raised that the impugned notice dated 11/9/2025 is issued by authorities who are not conferred, who are not vested with jurisdiction to issue such notice. And in this regard, the provisions of Rule 3B and 3D, small d, small b, of the Assam Cooperative Societies Act, Societies Election Rules, Assam Cooperative Societies Election Rules, 2019, were pressed into service. Full stop. 3 both Sri Talukdar, the learned standing counsel, and Sri Roy Chaudhary had, however, submitted that the said issue, the said point was not even an issue in the pleadings, and the primary grievance was with regard to the induction of 47 new members in the society. Full stop. Be that as it may, this court had directed the learned standing counsel to obtain instructions on the point raised, which is purely a point of law. Full stop, para. Sri Talukdar, the learned standing counsel, has submitted that the notice dated 11/9/2025 was issued in accordance with a resolution and cannot be deemed to be a notice, to be the final notice. Full stop. He has placed before this court a notice issued by the election officer on 11/9/2025, fixing the venue, time, and all other details. Full stop. Para. In view of the above, comma, the issue sought to be raised does not prima facie appear to be does not prima facie appear to be correct. Para. Be that as it may, let notice be issued, returnable by 4 weeks. Sri Talukdar, the learned standing counsel, accepts notice on behalf of respondent numbers 1, 2, 3, and 4. 5 by P.K. Roy Chaudhary. Then rest 6 to 40, 54 by registered post with AD. Steps within 2 working days. Of yes. But how do you make their votes separately? Can they vote separately? Okay. Yes. Since this court has also considered the interim, is there an interim prayer? Interim prayer. Interim prayer. Full stop. As noted above, the petitioner has questioned the rights, the induction of the 47 new members who would exercise their right to franchise in the election scheduled on 28, full stop, para. To balance the equities and it is provided that while there will be no restriction for the new members to cast their vote in the ensuing election, on Sunday, comma, their votes are to be their votes, public ballot papers, are to be collected separately, and sufficient and steps be taken to segregate their ballot paper so that segregate their ballot paper. Full stop. It is this the aforesaid direction has been issued to protect the rights and interest of both the parties. Do the votes of the new members would be counted, comma, the ballot papers are to be kept separately. No, including that, that is why. Now we have also that is why you'd include that, but you keep it separately. Okay. Yes. Yes. Good. Okay. Wish you all a very happy vacation.